I'm Beverly, and I'm on the witness stand.
Hello, everybody. We are in part 3 of the Lindsay Clancy recap of week 4. This time, we are in the defense case, and we are going to have testimony from Dr. Paul Zeizel, Zeizel. He is one of the biggest witnesses for the defense that I think that they're going to call. So let me start out by saying, because the prosecution's going to bring it up, he is a friend of Dr. Zeizel is a friend of Reddington. They have done many conferences together from different directions, okay? Different directions. Zeizel is like psychiatric, and Reddington obviously is from the legal system. So he's called him in for a lot of cases. They have worked together many times. Reddington believes in him. Reddington knows how qualified this guy is. Just to give you, I can't give you the whole list, but I will tell you that he has worked with the FBI, CIA, all those little letters, and he has worked over in Afghanistan, and he has worked with all of these police, firemen, everybody you can imagine, to help with the PTSD, the trauma, trying to help them get through those tough times. He's got a CV so long. I won't get into that, but let me just say, impressive to say the least. Okay, so he evaluated Lindsay shortly after the killings and has met with her dozens of times. I think it might be like 60 now times. So, we're talking about treatment now, okay? He was the one that was brought in after Reddington got a court order to let him in the room to speak with her and to do an evaluation and see where she was at mentally, everything. He needed to know the back part, and he needed to know, all of everything, records, how she was right then, what happened on January 24th, everything. While he was working with Lindsay in her hospital room, there was a nurse because she had to be supervised at all times. I want to talk about the fact, I know there's security, but she was metal cuffed to the bed while the whole time. But think about this, while she is intubated, while she has all of this medical stuff on her, where is she going to go? Was that really necessary? Or couldn't they have put her in soft cuffs? But they didn't. They put her in hard metal cuffs. It was just a side note. You probably know where I'm going with my opinion. He was one that came in then, and then he started working with her, okay? His major testimony was that Lindsay believed her thoughts had become so loud that strangers could hear them. Remember I said in part 2 about the school where she thought people were knowing what was going on and that she was worried about that? She was getting paranoid. She feared her children would be taken from her. Now, remember, the other guy said that he supposed that, one of the other witnesses, but Dr. Zeizel said she did, and that was part of her treatment, so it's in the notes, okay? She experienced auditory hallucinations and increasingly intrusive thoughts. Zeizel explained that a psychotic person, and this is what I've been waiting for because there are studies on it, there are peer-reviewed articles. Zeizel explained that a psychotic person can still talk, drive, use a telephone, and complete ordinary tasks. Psychosis does not require someone to appear bizarre every minute. That throws out a lot of the prosecution saying that she was deliberately faking all of that stuff. Like I said, I was very impressed with his resume. I feel like this guy knows what he's talking about. The Patrick telephone call. When he was in that hospital room, he let her use his phone to call Patrick. She was on speakerphone so he could hear this, and it was like a joint session, okay? The first time she called, he didn't answer the phone. The second time, he did. And this was days after the killings, okay? Lindsay reportedly told Patrick she loved him, a male voice told her she had no choice. The voice ordered her to kill the children and then herself. Okay, well, the prosecution went after that, and it was obvious. The commanding voice account was not documented before the killings, and Zeizel said also that Reddington had contacted him and entered the case shortly after. They went on the friend thing, that they knew each other. So this was at the end of day 15. He started testifying, but he came back the next day. So at the end of the day, I think for the first time, the jury heard a direct explanation for the killings, that she believed a voice was commanding her to act. And it was a major defense moment. But the timing of the disclosure left the Commonwealth room to argue fabrication or suggestion. They're still in it believing that she faked everything and that it was premeditated. Okay, Zeizel delivers the defense's opinion. This is on day 16, Wednesday. She had worsening symptoms. Lindsay believed her brain was damaged. She feared she'd never recover. She believed other people could hear her thoughts. She feared the children would be removed. She called a suicide hotline twice and was turned down for any treatment. After leaving McLean, the intrusive thoughts and voices continued worsening. According to Zeizel, the voices were telling her to kill herself. His critical opinion here is that he diagnosed her with bipolar disorder, postpartum psychosis, and a qualifying mental disease or defect, which is what has to be proven in order for her to not be found guilty of premeditated murder. He testified that because of that illness, Lindsay could not appreciate the wrongfulness of her actions or confirm her conduct to the law. That directly addresses the Commonwealth's test for lack of criminal responsibility. But Buckingham was not through. This was one of the Commonwealth's better cross-examinations. The commanding voice. Commonwealth went after it and said Lindsay never clearly described a voice to her treating doctors before the killings. She used terms such as intrusive thoughts. Buckingham suggested that the voice account developed only after Reddington and Zeizel became involved. So what does that mean to you? I think that they're trying to say that they cooked this up. They manufactured this defense. She also said a possible bias. Zeizel spent approximately 35 hours evaluating Lindsay. Now, I don't know if that includes all the visits or not, or maybe some of the visits were not evaluations. Maybe some of them were just like talk therapy. I don't know. But that's what he said, 35 hours evaluating Lindsay. He acknowledged caring deeply about her. Now, a lot of people get uncomfortable with that because a psychologist, psychiatrist, or treating provider is supposed to remain completely neutral. But I suggest that when you have a case like this and you work with a person, and this is such catastrophic events, that I think you can't help but care about. Doesn't mean he's fallen in love, doesn't mean all that stuff, doesn't mean he'll lie for her. He just cares for her. I care for her. She talked about that, and she said, have you spent that much time with very few other defendants? Or she said he had. And he agreed to that. He said he had. And she asked him how many cases had he worked on this long and cared about. And he said one other. I got a good cross on that. Prosecutors showed footage of Zeizel appearing at a press conference with Reddington. Didn't I tell you before on one of the parts, the previous parts, that in the beginning, Reddington readily admitted they were friends and that he had used him on many occasions for psychiatric evaluations and psychiatric testimony. He had testified many times for Reddington, but guess what? He had testified many times for the Commonwealth of Massachusetts. Is that a wash? You tell me. All right, so she said that she felt like, well, she suggested that maybe Zeizel began with a theory and then interpreted everything else to support it. He said absolutely not. Now, Tewksbury is the hospital where she's at now. I want to say that she had gone to Tewksbury before, but I don't remember what happened. But I may be completely wrong. But that's where she's at now. Buckingham emphasized records showing Lindsay playing dominoes, attending coffee groups, interacting with other patients, receiving family visits, sometimes appearing in reasonably good spirits, and not attempting suicide again. The apparent suggestion was that Lindsay's current records did not reflect constant grief or severe illness. Does that make sense to you? Remember, Zeizel says you don't have to be in a permanent sense of depression, that you have lucid moments. You're not acting psychotic all the time. What do they want her to do? I mean, do they want her to be depressed and psychotic for the rest of her life? Is that what's going to make them happy? Even if she goes to prison, if she's found guilty and she goes to prison, she's going to have time in prison where she smiles, where she actually interacts with other prisoners. This is not good evidence, I don't believe. Zeizel's response to that was Lindsay remains on continuous one-to-one suicide monitoring. Remember I said that there was a nurse in the room when Zeizel spoke to Lindsay the first time? There still is a nurse with her all the time. In fact, in the trial, there are 2 nurses that sit behind her that help her at any time she needs help. She has bad days and she has worse days. She talks about the children frequently. She loves them. She misses them. She thinks about them almost constantly. And ordinary activities do not mean someone is free of mental illness. What do you think? Comments? Well, Beth's opinion, Buckingham placed dents in Zeizel's independence and methodology, but she did not force him to retreat from his diagnosis or his criminal responsibility opinion. End of his testimony. And I've talked shortly here. This was a very long testimony, but this was really the highlights of what came out of it. Now we have, this was interesting, Emily Thorndike. Get this, the TikTok witness who never reached the jury. And she is a licensed clinical social worker. She watched the trial and posted a viral TikTok criticizing descriptions of McLean. Reddington learned about her through TikTok and attempted to add her as a witness. She testified in voir dire hearing outside the jury's presence. She disputed claims about the amount of individual therapy and physician attention patients received at McLean. Prosecution's trying to act like they don't have individual therapy, but they do. So she disputed that. Remember, she worked there before, but she no longer works there now. So the judge ruled he found her credible, but she stopped working at McLean approximately 1 year before Lindsay's admission. So he said her testimony therefore had limited relevance. He excluded her, so she couldn't testify. But he told Reddington he will allow the defense to use actual McLean staffing and program records instead. So he can get somebody from McLean now. Bev's opinion. First of all, I wouldn't have gone to TikTok. I think TikTok just undermines her completely. Reddington's larger argument about McLean may have some merit, but finding a witness on TikTok was just unmistakable with courtroom improvisation. So court ended there because of some unforeseen circumstance. I don't know what it is. I don't know that anybody has found out yet. I am bringing this to you. I'm day 18 on Friday, August 21st. We're going into day 17, which was Thursday. It was a very short day. One witness, make sure it was one witness, and I found this to be very compelling. She was the chaplain, Sheila Kavanaugh. She counseled Lindsay at Brigham and Women's Hospital. She was intubated. When she first came to talk to Lindsay, she couldn't because Lindsay couldn't talk. She was intubated, immobilized, and surrounded by medical equipment and police. Kavanaugh described her as being covered in medical armor. That's interesting, isn't it? They spoke after Lindsay was extubated. Lindsay, the first thing she said, get ready, she was glad that her children were safe. Lindsay did not know what she had done. I don't know if she knew what she had done the day she did it. I think she did. But with all of what had been going on, she told a chaplain she was glad that the children were okay and safe. And here's what Kavanaugh said to her. And again, I think this might have been the first time after she was extubated. And after you go through that, you can lose some memory. So maybe that's what happened. But Kavanaugh said that she answered from a theological perspective that the children were safe in heaven with God. Lindsay also described a voice warning that if she did not follow his command, neither she nor the children would be safe. And, this is confusing to me because Bev's opinion, this is confusing to me because I know that she knew that she had killed the children at some point. When she was laying on the ground, she told Patrick that the children were in the basement. Now, at that moment, did she remember? Because she had a significant injury. Did she remember what she had done? I don't know. But she did know enough to say that she had killed the children, with Zeizel and with Reddington. But I don't know. Let me look here and see. This is my notes. I don't see anything here that said that she spoke to Lindsay before Zeizel and Reddington. Apparently, one lawyer got called in and then Reddington came in. So I don't know if the family brought him in and the first one was court appointed just to, cover her in the beginning. I don't know. All I know is Reddington was almost from the beginning. I don't understand really why she didn't know at that time. Could it be that the chaplain could come into the room before anybody else, because it was days before even Reddington could get that court order to get in? So I don't know about that. And I do know that once people are extubated and on life support, that memories are either lost or clouded. Plus, remember that she coded and had to have CPR. I don't know who said to do CPR. I think at that moment, Patrick was the guardian of her care. Later, she asked her parents to be. She said that they would have her best interest. Bev's opinion, I kind of wonder if she thought that Patrick might not let her do a DNR, a do not resuscitate. But I think her parents would let her go because I think that's what Lindsay wants. I know they don't want to, but I'm wondering about that. What do you think? Comments. So how did this help the defense? The chaplain provided evidence that Lindsay's belief about the voice was not limited to conversations with Reddington or Zeizel. And the idea that the children were now safe may support the defense theory that Lindsay acted under a delusional belief that she was protecting them. Cross-examination. Kavanaugh did not record the voice in her contemporaneous notes. Her notes included Lindsay's fear that she might never walk again. Lindsay said she was deserving of this. The prosecution used those entries to suggest, the entries being her notes, to suggest rational, practical thinking and awareness of consequences. So I think Kavanaugh corroborated the voice account, but the absence of that crucial detail from her written notes give prosecutors a legitimate credibility argument. And then the jury was dismissed. So then we are going to go into day 18, which will be Friday, which is when I'm filming. There's going to be a battle, or there was a battle, over possible verdict choices. The Commonwealth's, this was outside the jury's presence also. The Commonwealth's request wanted instructions covering, they do this when they get close to the end, first-degree murder through premeditation, first-degree murder through extreme atrocity or cruelty, second-degree murder, consciousness of guilt, and criminal responsibility. The defense, he wanted to add involuntary manslaughter based partly on involuntary intoxication. And he wasn't talking about alcohol, he was talking about medication. His argument was the numerous prescription medication side effects, medications being increased, reduced, abruptly stopped, and the combined effect on Lindsay's mental condition. He wanted that one thing. I don't know if they're going to put it in yet, the jury will receive involuntary manslaughter. I think that might be a split the baby. I think that if the judge lets it in, that might be the thing that the jury goes with, which means there's some criminal responsibility, but they still may show that she didn't know what she was doing at the time. I don't know. The women in pink, I talked to you about that in a previous one. There's hundreds of women gathered outside the courthouse and hundreds gathered outside Tewksbury Hospital and in several cities. The demonstrations, again, was peaceful and focused on mental health and failures in psychiatric care. Public support is not evidence, but it demonstrates how far this trial's postpartum mental illness has reached. I think that the defense has its upper hand, but it's not a runaway. If the case went to argument or closing arguments today, I think the defense has created substantial reasonable doubt about criminal responsibility. The Commonwealth's rebuttal experts could still change the balance. So the Commonwealth has brought on, I think the defense has brought on a witness or two today, and then I think they've rested. And the Commonwealth gets to bring on their rebuttal witnesses. We are understanding that the jury will it will get to the jury next week, I think. Yeah, it will, because there's no way they can get to closing arguments today. So it will. I think the Commonwealth still has a piece that could go against Lindsay, but I also think the defense has the edge right now. What happens next? The defense reportedly has one physician remaining, and the Commonwealth has indicated that it may call 3 doctors in rebuttal. Of course, they can't do it one time. They've got to do it over. Reddington says he expects to rest by Monday. Judge Sullivan anticipates closing arguments Monday or Tuesday, and the court still must settle the verdict options and jury instructions. Now I'm going to tell you, when the jury gets in there and they do the jury instructions, that's already been planned by the judge and the prosecution and the defense. They've already worked all that out. Then he's going to start reading it to the jury. That is one of the most boring things I have ever seen. Juries will nod off because it's long. And I know it's the thing that has to be done, but I hate this part of a trial. So, closing thought. Commonwealth proved that Lindsay performed these terrible acts. How hard was that to prove? She said she did it. That's never been in dispute. Never. The question now is whether it has proved beyond a reasonable doubt that she possessed a criminally responsible mind when she performed it. We don't know. And I'll be bringing you part 4 at the end of today's testimony and get you caught up. It's a big week. I thank you for participating with me. In the meantime, please like, share, and subscribe to my channel. It really means a lot to me. And you may step off the witness stand.
I'm Beverly, and I'm on the witness stand.